Illustration of former President Trump's meeting with one of his lawyers at the federal courthouse in Washington last summer. While all eyes are watching every word offered by Donald Trump and federal prosecutors ahead of next week's crucial debate on immunity, third party has walked in through a side door with briefing that could dramatically thwart the former president's efforts to leverage the issue for maximum delay. Watchdog American Oversight, which is not a party to case, appealed to the U.S. Court of Appeals for D.C. He successfully petitioned Circuit to accept the friend of the court brief on grounds that it provided a unique perspective. The brief makes a seemingly compelling argument that court should not have heard this objection at all because court lacked jurisdiction, that is, authority to consider it in first place. If court agrees, it would mean dismissing appeal and returning case to U.S. District Judge Tanya Chutkan, abruptly canceling Trump's best opportunity to delay Jan. 6 federal trial. Litman A's shocking court decision in Colorado has turned Trump's campaign upside down. Trump's claim is that he has right to avoid prosecution because the Constitution prohibits impeaching him for conduct he undertook as president, at least if it was within outside of his official duties. Most observers, including me, think Trump will lose his argument on the merits. But the U.S. Supreme Court is likely to make this important decision. The question is when. Before trial, to put the case on ice, or after. Chutkan decided that he could not continue the hearing until this issue was resolved, considering that immunity was, first and foremost, the right not to appear at trial. This means that even if Trump is bound to lose his claim, he can drag out process by at least a few months and delay start of what is likely most important of 4 criminal trials he faces. The hearing, originally scheduled for March, is therefore being postponed further into Trump's campaign to return to the White House. Enter the American surveillance brief lawyers at the Washington-based firm Arnold Porter. The brief is based on the Supreme Court's unanimous 1989 decision Midland Asphalt Corp. The late Justice Antonin Scalia, etc., Midland Asphalt, defendant in criminal case, had unsuccessfully filed a motion to dismiss charges based on prosecution's alleged violation of grand jury rules. Litman Three takeaways from the most significant Trump indictment. Yet the Supreme Court ruled that neither it nor the Circuit Court had jurisdiction to hear the case on interim appeal or pretrial. As with vast majority of issues that may arise at trial, the court decided that this issue could only be evaluated after conviction. The court emphasized that the interest in summary trials in criminal cases requires courts to apply the doctrine of interlocutory appeals extremely strictly. Federal courts have jurisdiction over such appeals only if they are brought under a constituti.